Okay, picture this. You're a letter carrier, doing your route, maybe dealing with stairs, heavy packages. It's tough work, physical.
Definitely.
And then an injury happens. Your doctor checks you out, gives you clear, very specific instructions. No lifting over 5 pounds, or limit walking to 2 hours. Maybe no bending or twisting. Simple enough, right?
Seems clear, yeah.
But then your supervisor tells you to do something that, well, it goes directly against those orders. What happens then? What can you even do when your health is on the line and the doctor's note seems ignored?
It's a situation that, yeah, unfortunately does come up, but it's so critical for letter carriers to know they are not powerless here.
Mm.
There's a very specific kind of multi-layered system designed precisely to protect them in exactly that scenario.
Absolutely. And that's exactly what we're diving into today. This deep dive is really laser focused on the world of USPS City Letter Carriers, the challenges they can run into with work restrictions after an injury, and the, frankly, powerful protections built into their job.
Yeah, we've gathered the key documents that lay this all out. You've got the NALC USPS National Agreement, of course, the USPS Employee and Labor Relations Manual. Everyone calls it the ELM, and some really important grievance settlements that have set precedents, like M00487,
Hmm.
plus, critical forms like the OWCP Form CA-17 and guidance straight from the NALC union itself.
Right. So our mission today is to take this stack of rules, agreements, forms, and just make it understandable for you listening. We want you to walk away with a clear picture of a letter carrier's rights when it comes to medical restrictions.
And crucially, the actual step-by-step process they use to make sure management respects those restrictions on the workroom floor. It's about turning what looks like complex bureaucracy into, usable knowledge.
Okay, let's dive in. So the core issue we're tackling is supervisors ordering letter carriers to do tasks that just go beyond the physical limits their own doctor has explicitly set.
Exactly. That's the heart of the problem.
Which, I mean, immediately sounds dangerous.
Oh, it absolutely is. The risks are obvious: re-injury, making an existing condition worse. Plus, it's a direct violation of both the medical orders and established USPS policies.
Okay.
But the crucial point, the sources really hammer this home, is that letter carriers with documented limitations, maybe it's lifting, maybe standing time, specific movements they can't do, they're entitled to have those restrictions honored. Full stop.
So it's not just a nice idea, it's an entitlement. Why exactly is forcing them to work outside those limits a violation? What makes it a violation?
Because USPS has a clear legal obligation, really, to accommodate injured workers. When they push an employee beyond their medically defined limits, they're basically breaching that fundamental duty.
Okay, so it's required. This isn't optional for them. Where do these requirements actually come from?
They're really solid, actually. You've got federal law backing this up, specifically the Federal Employees Compensation Act.
Right.
That's overseen by OWCP, the Office of Workers' Compensation Program.
OWCP, right.
And these protections are reinforced by the NALC USPS National Agreement itself. So two strong pillars.
Got it. Federal law and the union contract. And what's the union's advice in this situation? What do they tell carriers?
Their mantra is pretty simple and direct. Work safe, and maybe even more importantly, use the contractual grievance procedure. The message is, don't just endure orders that could harm you. Document it and challenge it through the proper channels.
Okay, let's talk about that foundation then, OWCP, and this form, the CA-17. What exactly is OWCP's role here?
Okay, so OWCP is the federal agency that handles all workers' comp claims for federal employees, including postal workers. If a letter carrier has a job-related injury and their OWCP claim gets accepted, then the Postal Service is mandated. They have to comply with the medical restrictions that are determined through that whole claim process.
And OWCP, they want people back to work, I assume, but only when it's actually safe.
Precisely. Their goal is return to work, definitely, but only within the specific limitations the employee's treating physician has established. That doctor's word, once it's documented through OWCP, carries significant weight.
And that documentation, that happens mainly on the CA-17 form, the duty status report.
But that's the main tool, yeah. It's a two-sided form designed specifically for this communication between management, the doctor, and the employee. Side A is for the supervisor to fill out.
Okay.
They're supposed to describe the employee's normal job duties and the physical demands involved.
Right, so management describes the job on their side, side A.
Exactly. Then the employee takes that form to their treating physician, that's key, their doctor, who then fills out side B. The doctor notes the medical condition, the specific restrictions to, lifting limits, standing, sitting, reaching, whatever's relevant. and indicates if the employee can return to limited duty based on that job description on Side A.
Ah, okay, so the supervisor's description on Side A is supposed to inform the doctor's restrictions on Side B. That connection is important.
Yes, that's how it's designed to work.
Right.
And the significance of the CA-17 is huge. It's essentially a legal document in this context. It officially establishes your medical restrictions.
Right.
It's the basis for your entitlement to limited duty and maybe even wage loss compensation if you can't work your full hours.
Mm.
And, of course, it contains sensitive medical info, so it's protected by the Privacy Act.
So based on that CA-17, USPS then has to try and find suitable work.
Yes. Under OWCP rules and their own internal rules like the ELM, USPS has to make every effort that's the specific language to assign suitable limited duty work that fits within those documented restrictions from the CA-17.
Every effort.
But, and this is a key but, that obligation really kicks in if the employee provides sufficient medical evidence. Which means, getting that CA-17 properly completed by your doctor and submitting it to management.
Okay, so the carrier gets the CA-17 done, gives it to management. Management looks at it, and they might offer some kind of limited duty work. But I can imagine this is where things might get a bit tricky.
They absolutely can. Management might put together what they call a limited duty job offer. It'll describe the duties they think fit your restrictions. Now, you get that offer, and you absolutely must review it with your physician. Don't just accept it.
Okay. What if your doctor looks at the offer and says, no way, these tasks they've listed here, they go beyond the restrictions I put on the CA-17?
Then that job offer is, technically speaking, improper. It doesn't meet the requirements.
Yeah.
But here's a potential big hurdle. From OWCP's perspective, if you just refuse any job offer, they will evaluate if they consider it suitable. And initially, OWCP often takes USPS's description of the job duties pretty much at face value.
Oh boy. So let me get this straight. If the supervisor kind of maybe downplayed the lifting or the walking requirements on Side A of the CA-17,
Or if the job offer itself describes duties inaccurately.
then OWCP might think it was suitable work, even if your own doctor's saying, no, it absolutely wasn't.
Exactly. And that's where a letter carrier could potentially get into trouble with their OWCP benefits if they just refuse the offer without fighting it the right way. This is precisely why the union's role is so vital here. The NALC can and absolutely should file a grievance over any assignment or job offer that in practice doesn't comply with the doctor's restrictions.
Yeah.
That grievance forces management to actually adhere to the limits stated on the CA-17.
So if the job offer says, like, light lifting, but the CA-17 from the doctor clearly says no lifting over 5 pounds, and the job actually involves, moving tubs that weigh 10 pounds,
Yes.
the union grieves that specific discrepancy.
Exactly that. And the source materials, they highlight successful NALC grievances, where the union has actually forced USPS to pull back those improper job offers. And, crucially, force them to inform OWCP in writing that the offer they made actually exceeded the employee's documented medical limitations.
Wow. Why is getting USPS to tell OWCP about their mistakes so important? That seems huge.
It's a massive protection for the employee's OWCP benefits. Because if OWCP wrongly believes you refuse suitable work, federal regulations allow them to terminate your wage loss compensation.
Ouch.
So by forcing management through the grievance to correct the record with OWCP, the union helps safeguard those vital benefits from being unjustly cut off.
Wow. Okay, that's a really critical piece of the puzzle. So the core insight here seems to be that the CA-17 and that OWCP documentation, they are the absolute bedrock for any challenge like this.
Absolutely.
They're the proof of your restrictions, and they empower the union to protect your rights, even when dealing with OWCP. You have to get that CA-17, make sure it's accurate, keep it updated.
Couldn't have said it better. Without that clear medical documentation proving the restrictions, your case is just much, much weaker.
Okay, so we have OWCP and the CA-17 as the foundation. Are there other layers of protection, maybe within the contract itself or USPS rules?
Oh, absolutely. The protections are woven into multiple parts of the system. It's not just OWCP. You got to look at the USPS Employee and Labor Relations Manual, the ELM. Section 546.142A is really key.
And the ELM, that's incorporated into the national agreement, right? So it's binding.
Yes, exactly, via Article 19 of the National Agreement. So ELM 546.142A isn't just policy, it's contractually enforceable. And it's very direct. It says USPS must make every effort toward assigning the employee to limited duty consistent with the employee's medically defined work limitation tolerance.
Consistent with.
That phrase, consistent with the employee's medically defined work limitation tolerance. That's the critical part.
Yeah, consistent with doesn't sound like it leaves a lot of wiggle room for interpretation.
It really doesn't. It means any work they assign must align with what the doctor put on that CA-17. So if a supervisor ignores the CA-17, gives you work outside those limits, they're not just being difficult, they're violating official USPS policy.
Which, because of Article 19,
Is also a violation of the national agreement.
right.
It's a double whammy, really.
Okay, so it's a violation of policy and the contract. What about the man agreement itself? Are there specific articles?
Yep. Article 13, which is titled Assignment of Ill or Injured Employees, talks generally about accommodating employees, making every effort for safe assignments. Now, it often comes up more with light duty for non-work injuries, but the principle of, due consideration and safety overlaps very strongly with limited duty for on-the-job injuries.
Makes sense.
And then there's Article 14, Safety and Health. This one's huge in these cases.
Yeah, forcing someone to ignore their doctor's orders, that has to be a safety issue.
Yeah, it is, explicitly.
Yeah.
Article 14 requires the employer, USPS, to provide safe working conditions, period. Ordering a carrier to perform tasks that violate their documented medical restrictions is fundamentally ordering them to work in an unsafe condition.
Okay.
So the union can grieve this under Article 14, arguing that management is basically requiring the employee to take unnecessary risks with their health and safety, which the contract flat out prohibits.
That's a really powerful connection to make, linking it directly to safety. And you mentioned grievance settlements earlier, like M documents.
Yes, exactly. These national level settlements, the M documents, they function kind of like legal precedent within the grievance system. M00487 is a classic example. It confirms that management must instruct employees on light or limited duty to perform only those duties permitted by the physician's instructions.
Okay, hold on. So if my doctor said no lifting over 5 pounds and the supervisor orders me to lift something that's 10 pounds, that's not just ignoring my doctor. It's a direct violation of a national settlement like M00487.
Absolutely. Any task assigned that falls outside the specific doctor's orders is improper, based on this established, agreed-upon precedent. Citing these settlements in your grievance makes it really undeniable that management's action is a clear violation of the mutually agreed-upon rules. It adds a lot of weight.
Gotcha. And are there other USPS handbooks or manuals that back this up too? You mentioned EL 505.
Yeah, things like the EL 505, which is the Injury Compensation Handbook, and other management instructions, they all reinforce the same principle. Medical restrictions must be honored. And violations of these handbooks can also be grieved under Article 19, because Article 19 incorporates handbooks and manuals.
So even the paperwork requirements.
Right. Management has obligations regarding the CA-17 itself. They have to provide it to the employee promptly, cooperate with the doctor getting it filled out. So if a supervisor just refuses to give you a CA-17, or they fill out Side A improperly and refuse to fix it, that refusal itself is also grievable. Compliance with that paperwork isn't optional for management either.
Okay, wow. So if management orders work outside your restrictions, you've got multiple angles for a grievance. ELM 546, Article 13 for accommodation, Article 14 for safety, Article 19 bringing in the ELM and handbook violations, plus these national settlements like M00487.
Exactly. A multi-pronged attack, basically.
So how do you actually start that process? How does the grievance procedure work?
Okay, the grievance procedure in Article 15 is your vehicle. And the absolute number one thing to know is timeliness is non-negotiable. If a violation happens, you have to act fast.
Time is really, really critical here. Okay, let's walk through the steps in Article 15. Where does it start?
It begins at informal Step A. And the critical timeline here is 14 days. You must initiate the grievance within 14 calendar days of the incident happening, or, importantly, within 14 days of when you reasonably should have become aware of it.
14 days. That's the absolute starting gate.
That's it. First thing you do, contact your shop steward immediately. Don't wait. Explain clearly. I was instructed to perform work that violated my documented medical restrictions from my doctor. The steward, or if you absolutely can't reach a steward right away, meets informally with your immediate supervisor.
What needs to happen in that informal meeting? What's the goal?
Be specific. State the issue clearly. Management ordered me to work outside my medical restrictions, and that violates the national agreement and USPS policies. You should try to reference the specific contract provisions you think were violated, ELM 546, Article 14, Article 19, and critically important, have your CA-17 or doctor's note ready to actually show the supervisor. This isn't just complaining. It's a formal notification that you believe a violation occurred.
And the goal is ideally to get the supervisor to just acknowledge the restrictions right then and there and stop the improper orders.
Exactly. Quick resolution is the aim. The steward usually documents this meeting on an informal Step A form noting the discussion and outcome. But remember that 14-day clock. It's unforgiving. You must get this initiated within those 14 days, or you risk the entire grievance being dismissed later as untimely. Doesn't matter how right you are if you're late.
Okay. If it's not resolved at informal Step A, which I guess happens.
It definitely happens. Then you move up to formal Step A. Now the union, usually the branch president or someone they designate, appeals the issue in writing. They use the standard joint NALC-USPS grievance form. And this appeal has to be submitted within 7 days of when informal Step A concluded or was denied.
Another tight timeline, just 7 days for that appeal.
Yes, the timelines keep rolling. Once that appeal is received, a meeting has to be scheduled within 7 days. This meeting involves higher-level union representation, like the branch president or designee, and higher-level management, often the postmaster or their designee.
What's the objective of this formal Step A meeting? Is it different?
It's a more formal review. They review all the facts, they exchange all the relevant documents. This is where having your evidence collected is crucial. The CA-17, any OWCP letters, witness statements, the job offer maybe, and they attempt to reach a settlement. Management is supposed to issue a written decision on the grievance at or shortly after this meeting. The union's appeal documents will include detailed written arguments citing all the violations and specifying the remedies they're seeking.
Right, remedies. What sort of things can the union actually push for as a resolution?
Well, the standard remedies include things like a cease and desist order, basically telling management to stop ordering work outside restrictions immediately, maybe requesting a letter be placed in the supervisor's file noting their violation for accountability. If you were maybe sent home for refusing unsafe work, or if you got re-injured and missed work because of the improper order, the union would absolutely seek administrative leave or back pay to make you whole for those lost hours. And critically, if management tried to discipline you for this incident, maybe they gave you a letter for failure to follow instructions. Getting that discipline completely voided is a key remedy.
Okay, that makes sense. So if formal Step A doesn't resolve it or they reach an impasse.
Then, within 7 days of the formal Step A decision or lack thereof, the NALC appeals to Step B. This moves the grievance up to the district level. It's handled there by a 2-person team called the Dispute Resolution Team, or DRT. It's always one NALC representative and one management representative.
A joint team. And how long does the DRT have to decide?
They review the entire case file, all the documents, arguments from both sides from the lower steps, and they have to issue a joint decision or a decision letter within 14 days of receiving the appeal at their level.
Okay, 14 days for Step B. What are the possible outcomes there? Can they settle it?
Yes. The DRT can agree the union is right and sustain the grievance, meaning the union wins. They can reach some kind of mutually agreed upon settlement, or they can declare an impasse. That means the NALC rep and the USPS rep on the team simply disagree and can't resolve it together.
And if they impasse?
If they impasse, that clears the way for the union to appeal the grievance to the next and usually final step, arbitration.
So Step B is really the last internal chance to resolve it before it goes to an outside party.
For most contract grievances, yes. That's why having a really solid, well-organized file submitted to Step B is crucial. You want everything in there, all your documentation, CA-17s, doctor's notes, OWCP stuff, relevant handbook sections highlighted, copies of prior settlements like M00487, witness statements, and a strong, clear written argument from the union summarizing the case.
Got it. And finally, arbitration.
Right. If it's still unresolved after Step B, either through an impasse or maybe a decision, the union disagrees with the NALC, can appeal to arbitration. They have 14 days to do this from the date of the Step B decision or impasse letter. This takes the case completely out of the hands of USPS and NALC and puts it before an impartial third-party arbitrator.
What actually happens at an arbitration hearing?
It's basically like a mini court case. Both sides, the union and management, present their cases. They can call witnesses, submit all the evidence, make legal and contractual arguments. In a case about medical restrictions, things like your physician's testimony, or at least a very detailed written statement from them, is powerful. Your up-to-date CA-17 is obviously central, and testimony about how the supervisor's order could have harmed you or did harm you is key.
Given how clear some of this language seems like in the ELM about being consistent with restrictions, and Article 14 on safety, and settlements like M00487, it really feels like the union would have a very strong case in arbitration if management just blatantly ignored documented restrictions.
Oh, they absolutely do. Assuming the documentation is there and the facts support it, the grounds for proving management violated multiple contractual obligations are usually very strong. An arbitrator has the authority to order management to stop the violations, to make the employee whole for any losses like lost pay or medical costs, and might even order specific remedial actions like requiring supervisor retraining on limited duty procedures.
And I imagine a lot of these cases might actually settle before they even get all the way to an arbitration hearing.
Yes, that happens quite often. If the union presents a really strong, well-documented case file at Step B or even at Formal A, management might see the writing on the wall. They might realize they're likely to lose at arbitration and decide it's better to settle the grievance on terms favorable to the employee rather than risk a binding arbitration award against them.
Okay, so just to quickly recap those timelines again, because they seem so important. 14 days initially to start in Formal A, then 7 days to appeal to Formal A, 7 days for the Formal A meeting, another 7 days to appeal to Step B, 14 days for the Step B decision, and finally, 14 days to appeal to arbitration. Wow. It really demands prompt action from the carrier and the union.
It absolutely does. And that's where the carrier's role is so critical, getting all the documentation together quickly, notifying the steward immediately so the union can meet those deadlines. Because, like we said, an untimely grievance is almost always a lost grievance, no matter how valid the complaint.
Okay, that covers the formal process really well. But what about, the heat of the moment? You're standing there face to face with a supervisor who's giving you an improper order that goes against your doctor's note. How do you protect yourself right then and there?
Yeah, that's the immediate practical challenge, isn't it? This is where knowing some key strategies and, again, documenting everything becomes your personal defense system.
We often hear that phrase in union environments. Obey now, grieve later. Does that always apply, even if the order might actually physically harm you?
That is the general rule, and it's primarily to avoid charges of insubordination, which can lead to discipline, even termination. The idea is you follow the order, even if you think it's wrong, and then you file a grievance saying the order itself was improper. However, and this is a really important however, there's a critical exception. You may have the right to refuse an order if complying would pose an imminent danger to your health or safety.
And violating a clear medical restriction from your doctor? That feels like it could be imminent danger, doesn't it?
It absolutely could be. If your doctor says no lifting over 10 pounds and your supervisor orders you to lift a 50-pound box, that seems pretty clearly dangerous, right? The challenge is management might not agree with your assessment that the danger is truly imminent. They might argue it's not. So the safest course of action, the one recommended in the sources, is usually this. Politely, firmly, remind the supervisor of your specific medical restrictions. If you have a copy of your CA-17 on you, show it to them. State clearly something like, based on my doctor's written restrictions, I believe performing that task would endanger my health.
Okay, what if they still insist? Just do it.
If they continue to insist, you should state clearly that you will attempt it under protest. Make it absolutely explicit. I am attempting this under protest against my doctor's medical instructions and because you are ordering me to do so. This creates a verbal record of your objection right then and there. Now, if the task is genuinely physically impossible for you, you literally cannot lift the weight. For example, you need to make that fact clear as well. I physically cannot lift that.
And then, immediately after that whole interaction, win or lose the argument right there.
Call your shop steward or union representative immediately. Do not wait until break time or after work. Describe exactly what happened. What you were ordered to do, what your restrictions are, what you said, what the supervisor said. They might be able to intervene right away, maybe come talk to the supervisor. And remember, those national settlements like M000487 back you up. They say you should only be assigned duties within your doctor's orders.
Okay, and if you do end up performing the task under protest?
The key is to do so as safely as humanly possible, but listen to your body. Use proper techniques, take breaks if needed, but only do what you physically can without causing further injury. Your long-term health is far more important than completing one unsafe order. And that under protest statement you made, that's crucial documentation for the grievance that needs to follow. Which brings us right back to the absolutely vital step. You have to document every single incident related to this.
Cannot emphasize this enough, it seems. What kinds of details should a carrier be writing down? Assume they need specifics.
Everything relevant. Date, time, exact location, who was involved, what exactly was said, as best you can remember quotes as possible by you and by the supervisor. What specific task were you ordered to do? What was your precise response? I reminded them of my CA-17. I stated I would attempt under protest, etc. Were there any witnesses? If any coworker saw or heard the exchange, or saw you performing work that clearly violated your known restrictions, politely ask them later if they'd be willing to provide a brief, factual written statement.
So a witness statement could be as simple as like, on Juneteenth around 9 a.m., I saw Supervisor Smith tell Carrier Jones to load the hampers, even though Jones showed Smith a paper and said his doctor restricted his lifting, something like that.
Exactly like that. Simple factual observations are incredibly powerful evidence in a grievance. Keep a personal log, maybe just a small notebook you keep with you dedicated just to these incidents. Save any written notes, emails, text messages from management about your assignments or restrictions. And crucially, if management issues any kind of discipline related to this, maybe they write you up saying you were working too slow. Or for failure to follow instructions, when you hesitated on the unsafe order, give that disciplinary letter to your steward immediately. That discipline itself will need to be grieved, likely alongside the grievance about the improper order.
So persistent, detailed documentation is absolutely key. What about keeping the medical side up to date?
Just as critical. You need to keep your medical documentation meticulous and, importantly, current. Get your CA-17 updated regularly, maybe after every significant doctor visit related to the injury, or perhaps even proactively every 30 days or so if your condition isn't fully stable or resolved. This ensures your documented restrictions always reflect your current medical status.
And share that updated CA-17. Don't just keep it.
Oh yeah, absolutely share it. Provide copies to management promptly. And it's smart to have proof that you gave it to them. Maybe send it via email so you have a dated record, or ask them to initial and date a copy acknowledging they received it. Also, always provide copies to your union steward or branch representative. They need it for your grievance file and to stay informed.
Okay.
And one more point on the medical side.
Hmm.
If you are forced to do work that you feel aggravates your condition, go back to your doctor as soon as possible. Explain what happened, what task you were made to do, and have the doctor specifically document that the aggravation was caused, in their medical opinion, by being ordered to work outside your established restrictions.
And if that aggravation is significant, maybe causes you to lose time or need more treatment.
Then you should file a new OWCP claim, form a CA-1 for a traumatic re-injury, or a CA-2 for an occupational disease type aggravation if it's appropriate for the situation. Or at the very least, notify your OWCP claims examiner in writing about what happened. This is a direct way to officially signal to OWCP that management disregarded your restrictions and that action resulted in further injury or worsening of your condition. It creates an important paper trail with the compensation authority.
That makes sense. Going back to the CA-17 form itself for a second, you mentioned Side A is filled out by the supervisor describing the job. What if they're, let's say, less than accurate? What if they deliberately downplay the physical demands?
Yeah, that's unfortunately a known tactic sometimes.
Hmm.
A supervisor might make the regular carrier job sound much easier than it actually is on Side A, hoping that the doctor reading it on Side B will then place fewer or less stringent restrictions.
Right.
It can be. So you absolutely should review Side A carefully before you take it to your doctor to fill out Side B. Read what the supervisor wrote. If you see significant errors or omissions, maybe they left out the stair climbing or understated the weight of mail tubs, you have the right to request that management correct those errors on Side A before it goes to the doctor.
And if they refuse to correct it? Or what if they refuse to even give you a CA-17 form when you ask for one?
The NALC guidance is clear. A grievance should be filed in those situations. Management is required under OWCP procedures and ELM rules to provide the form and cooperate with its completion. They can't just refuse. Insisting on an accurate Side A is really important because it prevents future disputes down the line about what tasks are truly suitable for you given your condition. It makes the doctor's restrictions on Side B much more meaningful.
Okay, so the carrier is doing a lot here.
Yeah.
Documenting every incident meticulously, keeping all their medical paperwork current and submitting it, pushing for accuracy on the CA-17, maybe getting witness statements. How does all of this come together to help the union win the grievance?
All of this becomes the evidence package. It's the ammunition the union uses to fight for you. You need to work closely with your steward or branch leadership. Compile everything systematically. Your OWCP claim acceptance letter is huge. That proves the injury is job-related and establishes your basic entitlement to limited duty consideration.
Right.
Then the latest, signed Form CA-17. Copies of any limited duty job offers management gave you and any written work assignments, relevant previous grievance decisions on similar issues in your office or nationally if the union has them, those crucial witness statements, your personal log of incidents. This comprehensive file gives the union everything they need to build a compelling evidence-based case as they move through the grievance steps, Informal A, Formal A, Step B, and potentially arbitration.
We touched on this earlier, but can we revisit the OWCP implications? How does using the grievance procedure specifically help protect your OWCP benefits compared to just saying, nope, I'm not doing that unsafe task?
Okay, yeah, this is critical. If you just outright refuse work without going through the proper channels, it can lead to OWCP potentially suspending or terminating your wage loss compensation. This happens if USPS tells OWCP that you refused an offer of suitable work. Now, federal regulations say you are not penalized for refusing unsuitable work.
But the catch is proving it was unsuitable.
Exactly. The burden of proof can sometimes fall on you, the employee, to convince OWCP that the work offered wasn't suitable, especially if USPS gave OWCP a misleading or inaccurate description of the job duties in the first place.
And the grievance process helps establish that proof.
Precisely. Filing a grievance creates an official, internal record challenging the suitability of the work based on your documented medical restrictions. More importantly, a successful grievance resulting in a decision or settlement provides formal confirmation that the assigned duties were, in fact, beyond your documented medical limits. The sources strongly caution against just quitting or walking off the job if you're faced with improper orders. That puts both your job and your OWCP benefits at serious risk.
So the recommended strategy is pretty clear then. Safely attempt the work under protest, documenting everything. Or, if it's truly imminent danger, safely refuse but clearly state why based on your restrictions and also state you're refusing under protest. And then, in either case, immediately contact the union and file that grievance.
That's really the best way the sources outline to challenge the improper order while actively protecting yourself using the established contractual and regulatory procedures. And a major benefit we mentioned, worth repeating. When the grievance is won, the decision or settlement confirming the job offer or assignment was improper can be sent directly to OWCP.
Right.
The union often specifically seeks a remedy in the grievance that requires management themselves to notify OWCP in writing that the work they offered or assigned actually exceeded your restrictions. This directly counters any potential false claim by management to OWCP that you just refused suitable work, thereby protecting your crucial compensation benefits.
It really sounds like success in these difficult situations relies heavily on using every single tool available in the toolbox.
It absolutely does. You have to leverage your rights under the union contract, Article 14, Article 19, ELM 546. You use your rights under the OWCP regulations, the CA-17 process, the right to have restrictions honored. You rely on your own meticulous documentation of everything that happens, and you absolutely depend on the expertise and support of your NALC representatives.
And involving the union early, staying in constant communication with your steward, maybe the branch OWCP specialist if they have one, that seems vital for getting the right guidance along the way.
Couldn't agree more. They know the process, they know the arguments, they know the precedents like M00487. The union can also use formal information requests to management to dig up documents or policies that might strengthen your case. And remember, while the grievance is proceeding, you still have to keep up with all of OWCP's requirements, submitting your CA7 claim forms for compensation, responding to their letters. You have to keep both tracks moving.
So, bottom line, use the contract, use the OWCP rules, document everything like crazy, and work hand in hand with your union every step of the way. That really seems to be the path to navigating this successfully.
That's definitely the path the sources lay out. It takes diligence, but the framework is there.
Okay. So this deep dive, I think it really shows that while being ordered to work outside your medical restrictions is a seriously difficult and potentially harmful situation, letter carriers actually have an incredibly detailed and pretty robust system of protections. It's built right into their job through their union contract and backed by federal law. It definitely requires knowing your rights and actively using the system, but the protections are there.
Absolutely. With the right information, that diligent documentation we keep talking about, and really leveraging the power of the union grievance procedure, carriers are well equipped to effectively challenge improper orders from management and ensure their health and their contractual rights are protected. It's not always easy, but the tools are there.
So, considering the sheer level of specific procedures we've discussed, mandated forms like the CA-17, strict timelines, multiple appeal steps, the formal grievance process, the federal OWCP oversight, all explicitly designed within this highly regulated environment of USPS, NALC, and OWCP, all aimed at protecting an injured worker's health and ensuring they can work safely. What does this entire complex system suggest about the potential vulnerability of employees in other industries? Industries maybe with far less formalized protections when they encounter similar challenges just trying to get their employer to respect basic medical restrictions after an injury.
Yeah, that's a powerful thought. It really makes you wonder about the safety nets, or maybe the lack thereof, for workers in sectors that don't have such comprehensive, hard-fought negotiated agreements and these strong federal oversight mechanisms baked into the system. It highlights how valuable these structures really are.